Good afternoon, everyone. I'm Barka Patel, the Director of Education for Pro Bono Partnership of Ohio. Welcome and thank you for joining us today for our Lunch and Learn webinar, Intellectual Property on a Budget for Nonprofits. Before we get started, I wanted to give you a quick overview of who we are and what we do. Again, we're Pro Bono Partnership of Ohio. Our mission is to strengthen our community. We engage attorney volunteers to provide nonprofits with free legal services tailored to their business needs. Our clients are 501c3 nonprofits that meet the following criteria. They have to serve low-income or disadvantaged people or significantly enhance the quality of life in our neighborhoods. These nonprofits must offer programs that have a demonstrable impact on the community, and they must be located or serve the Cincinnati or Dayton areas. And of course, they have to be unable to pay for legal services without significant impairment to their program. These are just some of the types of legal projects we handle. To give you an idea, they usually fall into the categories of governance and compliance, employment, intellectual property, contracts, real estate, really anything that you can think of except for litigation. If it even hints of litigation, we tend to kind of stay away from that. But a lot of the topics that you'll hear about today, as far as trademarks and copyrights and other ways to protect your intellectual property, our attorney volunteers are happy to help you with things like that once you become a client. Please note before we get started that this webinar is a general informational service to clients and friends of PBPO. It does not constitute legal advice, and you can kind of read through our disclaimer there, but we definitely think it's important for you to know that. And I want to introduce you to Vance V. Van Drake. He is an attorney at Ulmer & Byrne here in Cincinnati. And I'm going to turn it over to him to get started. And right before I do, I just want to let you know, if you have questions, feel free to type them in into the Q&A box. And there's also a little man up there with his hand raised. Vance may use that to pull you through the presentation, and you can kind of use that to do that as well. So thank you all for joining us, and let me turn it over to Vance.
Thank you very much, and thanks for having me come in today. Looking forward to it. There's a lot of, I think, misconceptions just generally about intellectual property, that it has to be a really expensive endeavor, and for that reason, a lot of people just kind of throw it out, you know. And kind of what I want here for today is to help identify some of those things. Probably change some myths, debunk some myths, and talk about some things that your organizations can do, both to protect yourself in your own assets, but also to make sure that you don't step on some landmines that might be out there. So we have this interactive feature. So kind of before we get started, who on here doesn't think they have any IP? Maybe you're here for another reason, doesn't have any intellectual property, and is maybe just here to kind of learn some background. Anyone? You have to hit the little man. Aaron is, yeah. All right, so now are these people saying that they don't? They're just saying it. All right, so I'm gonna assume that Juanita, thank you very much, didn't think that her organization has any intellectual property, and kind of one of the points is everyone does. So all your organizations do, whether you believe it or not, and a lot of that intellectual property has actually already been created in your organizations. And sometimes it's just a matter of identifying what's out there and having an understanding of the rights that you probably already have. So before we kind of dive into everything, this is me. That is not a stage name. that is my actual name. So I'm an intellectual property and patent attorney at Ulmer and Byrne, and when I was growing up, my mom told me I either had to be a lawyer or a duke. So, so I became a lawyer with that name. I work with a lot of entrepreneurs, so I'm used to companies and businesses that are bootstrapping. Um, I try to be very involved in our community here and try to give a lot of time just to helping people understand intellectual property. So I do a lot of. I'm a patent attorney. I've got a biomechanical background. Do a lot of trademarks, copyrights, trade secrets, and I help a lot of people out of jams. And I try to be very strategic about my approach to intellectual property. It's definitely not a one size fits all um, process, and there's a lot of things that you can do to add value to your organizations without necessarily spending a lot of money. So I kind of alluded to, kind of in the opening there, that there are some myths that persist, and it is understandable because intellectual property can get really expensive. There's no question about it. Um, but the first one that's probably the most common, and I see this with a lot of nonprofits, is that I don't have any. So most people, I think part of this is that people conflate patents a lot of times with intellectual property and see those two things as being synonymous. And it's true, it's maybe more unlikely that your organization has patentable technology, but I guarantee you that the other buckets of IP are relevant. So we'll get into those and kind of talk about some specific examples, but it almost 100% of the time you do have IP whether you believe it or not. So we'll talk about what that is. The second is intellectual property isn't valuable for nonprofit organizations. There's sort of a belief that nonprofits, it's all, hey, we're a nonprofit. Every other nonprofit, has a mission. We'll all, we'll be able to just work stuff out. Everybody will play nice. We're all kind of in the helping, charitable sandbox. For better or worse, that couldn't be farther from the truth right now. So some of the most litigious organizations out there around intellectual property are nonprofits. Susan G. Komen. So, if we'll talk a little bit about this in more detail, but if you're familiar with kind of the Race for the Cure and the Susan G. Komen Foundation, they are incredibly aggressive about policing their own intellectual property because they see so much value in it. And whether or not you want to go on the offensive, there's a lot of defensive things that you can do with intellectual property, just to make sure that your organization stays out of trouble. So you don't necessarily have to go that direction. There's a lot you can do that's not aggressive, and this kind of relates to the last myth that having IP, owning stuff, intellectual property assets, runs counter to the mission of the nonprofit. So I'll hear sometimes, the mission in some form is about inclusiveness. We want inclusiveness. We're creating this content today to share and to help people. The reality is that protecting your IP in a lot of ways fully harmonizes with that mission. If that's your goal, people still need to know it's you. They need to know if you're a trustable and reliable resource for content, for referrals, for connections, for help. They need to know that when they go somewhere that they're talking to the right person and that they haven't gone astray and that they're going to get some bad advice. So with your organization, I would suggest that intellectual property does have value and that it can perfectly harmonize with whatever the mission is for your nonprofit. So why should you care? We've kind of touched on some of the points generally about why I think there's potential value in intellectual property. But some of the bigger groups. This is a quote from Marcy Marsh from the World Wildlife Fund. um, it's your brand, right? If you can't protect your brand, a lot of negative things can stem from that. So if again, if the public gets confused, if they're not sure, a lot of it comes down to donations too. So if if you're looking, for financial contributions from various groups, you want to make sure that if somebody intends to donate money to your group, that you're getting the money. So, and if you don't have your brand protected, whether you could have protected it, and other companies, entities have similar names, for example, similar brands, it can dilute your ability to raise those funds, and that is kind of a direct line between how intellectual property can really add value for a nonprofit. So one of the kind of phrases that I like to use is what's your IP IQ? So your intellectual property intelligent quotient, uh, and this is there's a lot of misinformation that's out there about intellectual property. Some of it, specific to nonprofits, we touched on in the myths. But increasing your IP IQ even a little bit can pay real dividends for your organization. And so my goal with this presentation is to, I think, debunk some of those initial myths, but also that you can kind of walk away with a basic understanding of what intellectual property is, what are I call them the buckets of intellectual property that you might be able to protect, um, and then how to do that really cheaply. So a lot of these are free. So which again is another huge myth that you've got to spend a huge part of your nonprofit's budget to protect a lot of the stuff, and there are just a bunch of free things in several of the buckets that we'll touch on kind of throughout this presentation. It's really the low-hanging fruit. It's something that with your web developers, you could 20 minutes after this presentation probably go do the stuff that I'm going to suggest in this presentation. So the four buckets of intellectual property, we have patents, copyrights, trade secrets, and trademarks. I'm a patent attorney, but for this particular presentation, patents are probably the least relevant. We'll touch on those kind of at the end, just so we kind of get everything at least a little bit. But we'll spend most of our time talking about copyrights, trade secrets, and trademarks, because that's how you're really going to add value to your organization. It's also where the biggest landmines are. So it's one thing to go protect your mark, to be a little bit like a Susan G. Komen, where you're going to go out and send a bunch of nastygrams. It's another to try to avoid getting those nastygrams, because litigation is crazy expensive, and it's one way to really take you off mission, and eat up your budget, and a lot of times it's just unnecessary if you do some housekeeping up front. So we're gonna start with trademarks, and this kind of piggybacks off the World Wildlife Foundation quote. That this, trademarks in some ways are kind of synonymous with your brand. So who are you? You take a lot of steps and you make a lot of efforts to define your mission, to get public recognition, and that you do that for a lot of reasons. You need to find the people that you're trying to help, right? So you're out there, people, for the Pro Bono Association, you mentioned the services that you offer. It's a two-sided marketplace, right? You've got to have the people that know to come to you to get those services, and then you have to find the people to help provide those services. So your brand is partly to make sure that people out there that have a need, whatever that need is, can identify you, and then there's the financial component, right? There's always the financial component. So for it goes without saying for this group, but for nonprofits, state funding, corporate funding, all those things, that's the lifeblood of your organization. You can't offer the services if um, if you can't get those investments. And having a muddled, unprotectable brand is a really good way to deter investment. So it's much harder if you can't really clearly differentiate yourself from other people with your brand. What defines you from everybody else that's kind of out there with their hands out, because there's a lot of people with their hands out. So what is a trademark? Uh, it's a little jargony, but a trademark is any indicator of source. So the most common, most people know about is the name of the organization. So MoveOn.org, World Wildlife Foundation, Pro Bono Association of Ohio. Those primary business names are potentially a trademark because they tell people who's providing the goods and services. It includes this other stuff too. So your slogans, logos, branding, anything like that is also potentially a trademark. So anything that tells people, hey, this is my brand. You should believe in us. And this is where the word that we use in trademark land is goodwill. So you've built this goodwill in your organization. This is how we define that it's us. So there's even instances where colors and sounds. You've heard the NBC chimes at the end of an episode on NBC. If you're in the other room, you still know that's an NBC show because I can't have the worst voice, but I'm not gonna do it. but you know what I'm talking about. If you hear those chimes, that's a trademark. So that is, even though it's not written down, it's just those three notes that tells you where something is coming from. So one of the examples that I kind of alluded to this before is the Susan G. Komen Foundation, and their Race for the Cure to help with breast cancer awareness and to find a cure. It's probably 50-50 on what most people think about whether Susan G. Komen is really smart, or if they're kind of a bully. So they have a registration. They have a lot of registrations. They have over 200 trademark registrations. And this is internationally. I just did a quick search kind of for this presentation, and I found 102 live either pending or registered trademarks just in the United States. They've also got the pink ribbon you can see down there kind of on the left. They have a registration for that. And then on the right side, you can see just a list, and this is just a portion of their marks in the United States that they're pursuing or have registered. So as you can see, you attach pretty much anything to the cure or for the cure, and they're probably gonna come after you. You're probably gonna get a friendlygram or maybe a nastygram, a cease and desist letter from the organization telling you that they own that. So is it smart or are they a bully? Trademark applications are not inexpensive. They're not necessarily cost prohibitive, but I usually ballpark to get an application on file with the filing fee in a single class for around $1,500. But then there's a lot of prosecution that goes with that. It goes without saying, I think Susan G. Komen spent hundreds of thousands of dollars, probably maybe even millions, on just the initial protection of the brand, not to mention the enforcement of the brand. So what does that mean? That means when you're giving money to this organization, they're spending some of that money on this stuff. When you're when you're a corporation or an individual, and this could be a really important cause for you, you're you're giving money hoping that it's going for, the mission, when, probably not an insubstantial amount is going to intellectual property enforcement. So, you know, how do you feel about that? And I think it can be a little bit polarizing. This is an extreme example of their belief. The articles I've read, where you know they think that there is a limited amount of money that's available out there to go to these types of organizations, and they want to be 100% sure that when you're trying to give money to their cause, that it's coming to them so that they can fulfill their mission. So they believe that this is a wise investment in this much IP, because without it, the brand would be so diluted that they couldn't fulfill their mission. So that's the argument that they would make. On the other hand, if you kind of look down this list, you can't do really anything for the cure. Other organizations, and this happens all the time, and it can be really frustrating, where you want to do a cancer awareness event. Maybe it's even local. It's a bike for the cure, or it's a you know competitive eating contest for the cure. Who knows? It could seem totally off brand, and you're like, hey, we're a nonprofit. They're a nonprofit. Like, aren't we in this together? And the reality, and it's unfortunate, I think, but that is not the reality at this point. It is highly competitive right now, and so where your organization falls in this, I think, is just part of kind of what's on mission. How important is your brand to you, and what steps do you want to take to protect that brand? But then also, to be really aware that just because you're a nonprofit does not mean that you're not going to get sued. So a lot of nonprofits and for-profit companies are highly litigious when it comes to intellectual property. So the belief, maybe the false sense of security that, hey, because I'm a nonprofit, because what I'm using my branding for is for this amazing cause, and we're taking nothing off the top, therefore I'm gonna be fine. It's just not true. So you wanna protect yourself where it makes sense to do so, but you definitely want to avoid these landmines, and don't do anything for the cure. So especially that one. Yeah. So let's say you either don't have the coffers of the Susan G. Komen Foundation, or that's just not the tact that you want to take. What can you do? You're like, listen, we have no desire to maintain 200 trademark applications and enforce those. What can you do? There's a whole bunch of stuff that you can do. So trademark rights, and this is a common misconception, but trademark rights are actually based on use. So I ask a lot of people when I speak, that have their own businesses or they are nonprofits, who in the room has a trademark? And sometimes no hands go up, because everybody there assumes I mean a federally registered trademark, and they've never done anything formal. That's not right. If you're using a brand, that is a trademark. So just based on use, you have common law rights in that name, that slogan, that logo, that product. So the first step here is recognizing, oh, I'm already playing with intellectual property, even though I had no idea that I was doing so. So whatever that is, that name, that brand, could very well be a trademark. And just based on that use, and the way that you indicate that is you put the TM or the SM next to the product or the name, and we've all kind of seen like the superscript with brands that do this. This is 100% free. 100% free. You could go on your website right now and stick this next to everything you think maybe is an indicator of source. for your company. You can file a lawsuit just based on that to stop somebody else. Uh, these common law rights are more limited than getting the federal registration. But number one, it's absolutely a trademark and it's absolutely enforceable. Um, the main limitation is that there's a bunch, but the main limitation is that these common law rights they're only in your geographic footprint. So um, if you're a World Wildlife Foundation, that, as the name implies, is global. Even if you never registered anything, you might have pretty substantial common law rights. A lot of other nonprofits, though, it might be hyper local. So if you've got a name for your nonprofit and you're in Cincinnati, Ohio, where we are right now, um, and you're helping out a particular part of the community, and somebody in California, and it's usually not nefarious. They'll just come up with the same name. And some other state starts using it, but now they've got a website, and you're like, there's traffic confusion and some of these. You can't stop that person because they're outside of your geographic footprint. But if somebody down the street used a similar or the same name, you might be able to stop them. But at a minimum, put the TM or the SM next to anything that you think is an indicator of source. And the other thing I really like about that is, well, one, it's free, right, which is always great. The other is it makes you look really sophisticated, right? If your nonprofit is out raising capital, you want to look as legit as you can. That's part of your brand. You want people giving you money to trust that you're using the money for the things that you're telling them you're using the money for. So a lot of these IP things just make you look put together, make you look really sophisticated, and if you can do it for free, just why not, right? So for a federal registration, you might consider that for, oh, we have a question from in the room. So what is an SM? So that's actually a very relevant question. So TM is the one most people are familiar with, and that's a trademark, right? SM is a service mark. So you can use TM on anything, and that kind of gets the point across because each one of these is a notice feature. But an SM is for when you're offering a service. A trademark is a product. So technically, McDonald's, the least nonprofit company in the world, is an SM, and the Big Mac is a TM. So so for a lot of nonprofits, you will technically be an SM. You're offering a service, but as the pro bono organization, you guys use the TM. It's totally fine. So, and a lot of people that could use a TM or could use an SM will choose to use the TM because more people know what it means, and the SM just is confusing. So that's the free option. You could consider a federal registration for your primary name, and sometimes this is worth doing. So ballpark, to do the search and get your application is around $1,500, and for this, it's really is the juice kind of worth the squeeze. I wouldn't recommend if you have a limited budget to federally register all your slogans, your name, all your logos, all your products. For that core name, having a federal registration instantly gets you nationwide coverage. So if you have plans to expand, let's say you're in Cincinnati for right now, but that's just where you're starting. Your mission in 10 years is to be a nationwide nonprofit. What would be unfortunate for your organization is if you rely upon these common law rights, but before you expand into California, somebody else in California starts up with the same name. You wouldn't be able to stop that person based on your common law rights because that's not where your footprint is. Um, Getting the federal registration is a really nice way to say, listen, this gives us room to grow for our organization. The other really nice thing about a federal registration on a key brand is that you'll show up on TESS, which is the Trademark Examination search site, and that's accessible by anyone. You can just Google TESS, trademarks, and do some searches. Your name will then show up on TESS. That's important for two reasons. One is other people looking to pick a name. If they find you, they're less likely to pick that name, which is great. You'll never have a problem. The second is that's what the trademark office looks at. So when the USPTO, the US Patent and Trademark Office, does searches, they don't look at common law rights. They only look at this national registry, and if you're not on there, they might initially grant rights to somebody else that shouldn't have them. So one of the questions is, what happens if you don't use TM or SM and someone uses the name? Can you still ask them to stop or potentially litigate? So maybe it's a great question. So and that's kind of a good segue into how you use trademarks. So the purpose of the TM and the SM is as a notice feature. It's to tell the world, this is my brand. This is not just fair game for you to use. And so if you don't put that on there, the other side might take the position of, we didn't know. You didn't call it out as a trademark. But there's other things that are taken into account, whether something has been treated like a trademark. So one of the things that you can do and should do is, I'll kind of go back a few slides here, is, so I'm filing a federal trademark application for my slogan. What's your IP IQ? For educational services. It's technically an SM, but I use the TM for that. I've also called out the IP IQ part, right? You'll see some people that in the text of a website, it gets a little obnoxious. Like every time a word shows up, it's like bolded and underlined, and there's the TM, embedded in the document. That might be to the extreme, but what they're trying to do is say, listen, you can't ever pretend you didn't know I wasn't using this as a brand. The TM and the SM is the easiest way to really clearly set that off. But if you were also using it and you had stylized it, it's bolded, it's set off from other words, even without the SM or the TM, you might be able to take the position that you still have common law rights in that mark. So if you've been doing this, you haven't added the TM or the SM, and you feel like there might be an infringer that's out there, stick it on there right away, but it doesn't mean you're totally out of luck, necessarily, for stuff that's gone on in the past. And yes, to kind of answer the end of the question, you could absolutely send a letter, to somebody saying, hey, this is our brand. You're within our geographic footprint, you're infringing our common law rights, and please stop doing that. Yep. All right. So we're spending a lot of time on trademarks because this is usually the most relevant bucket for nonprofits. The second, so how to get kind of easy, fast protection on a name is something you should all know. This is really important too. So you've got to pick a name that you can actually protect, right? So I work for a law firm. If I try to trademark law firm for my law firm, intuitively that doesn't make any sense, right? Like that doesn't seem like it should be able, because then what's everybody else going to call what they do, right? So you're not allowed to trademark something that is in these first two. If you kind of see this arrow going up, this is the arrow of strength. The first two categories, generic and descriptive, um, are generally not protectable as a trademark. So uh, if you apply for something and you're describing exactly what your business does, and this is where the lawyers fight with the marketing people, because marketing people a lot of times, if we want to tell people exactly what we do, so they know, like, you know, World Wildlife Foundation is pretty descriptive, right? And we can talk about how they've protected that. But, if you're just starting out, something like World Wildlife Foundation, pretty clear what that organization is doing, um, especially for nonprofits that aren't looking at branding in the same way Procter and Gamble does, right? Where there's going to be a thing on the shelf and it's next to other things on the shelf, and mine's got to be different. So, but but if you acknowledge that there are a lot of nonprofits on the shelf, right, and you need to distinguish yourself from others, picking a name that you can own is really important, because if you start with something that's just generic or merely descriptive, you can put all the SMs and the TMs in the world, and it doesn't matter. So you just won't have any rights in something that doesn't meet a threshold level of protection. And so, where do we want you to be? So, the lawyers want you to be all the way at the top end of the spectrum. The fanciful or the arbitrary marks, and fanciful is just made up. So that's like Google, right? Uh, Kodak, these are just totally made up names. The organizations hate that because they're like, listen, we're going to have to build so much education into what this means for people to understand that. An arbitrary mark is using a word like apple. It would be generic if I'm trying to sell fruit, right? But if I'm selling computers, now Apple becomes a really strong trademark. So if you're using something for a totally different reason than the commonly understood meaning, it's a very strong potential trademark. Again, the companies hate that. So where we end up a lot of times is in this suggestive category. So the suggestive marks are kind of in the middle, and this is where we kind of compromise a lot of times between the companies and the lawyers. So one example I use here, and you can see some kind of here on the slide, Roach Motel, right? It's not. It would be generic if it was actually a hotel for roaches, right? So, right, we would not stay there. But obviously it's suggesting there's a connection to, like, they check in, they don't check out, right? So there's a connection, but it's not totally on the nose. That's where we kind of like you to see for a trademark, and really good protection starts there. If you're in the descriptiveness part, there are still some things that you can do, and we won't get into that in too much detail here just for time reasons. But if you are descriptive, there's still some techniques that you can do. You should still put the TM, put the SM, and those kind of things. But you're not necessarily out of luck. Sometimes though, you got to get really famous. So that's how the World Wildlife Fund and a lot of these organizations get trademark rights, is if something's still descriptive, but you're like, everybody knows that's us. It sounds descriptive, but it's not. Everybody knows that's us. You can still own that, but it's harder because, you got to get famous, right? All right, so how do you avoid landmines? When you have a key brand that triggers the risk, the standard here is likelihood of confusion. That's important just because somebody, it works both ways. Just because you're not using the exact name as somebody else doesn't mean you're fine. Is there potential confusion? So with the race for the cure, you can have competitive eating competition for the cure. That doesn't right? But that for the cure part, Susan G. Komen's try to own that, and they'd say, even though we don't have that specific one registered, this is still ours. So stay away from anything that's even close. If if you can. You know, there's two thresholds. The first is I'd have good arguments in court. By the time you're in court, you've already lost, right? It's too expensive. So pick brands, pick names that you're not going to even end up in court. Preliminary clearance searches are usually not that expensive. So I've got a group that does them for less than $500. We just give them to the clients sometimes. If it helps you to see what's out there before you pick a name, if it's a key brand, I'd encourage you to do that. And the litigation costs can get astronomical. So it's a little, there's a lot of free stuff. Sometimes a little money on the front end can, $1 million lawsuit for trademark infringement is a really unfortunate way for your organization to fail. And I've seen companies fail because of arbitrary name choices, and it's just sad. So we've spent the most time on that. We'll kind of buzz through the rest of this stuff, but copyrights are probably the second most relevant bucket to your organization. So what is a copyright? The first kind of sentence here is the legal definition. Original works of authorship fixed in the tangible medium of expression. That's all this stuff. So a lot of people have a pretty good working knowledge of copyrights just because it's in the news a lot. So you hear about the music lawsuits, and you hear about authorship kind of photography issues, those kind of things. So any authorship thing and fixed in a tangible medium is really broad. That could be a photograph, that's your website, that's a book, anything that your company writes, photographs, videotapes, is protected by copyright. And so that kind of segues into this point. This is a super important takeaway, and this cuts both ways. The copyright is created the minute the work is created. So when I ask people about trademarks, I'm like, who has a trademark? Very few hands go up. It's somewhat similar for a copyright. Let's say somebody's a photographer. I say, do you have any copyrights? They might sort of sheepishly be like, no, I don't. Because they haven't registered them. That's wrong. The copyright exists the minute they take that photograph. They've fixed that image. The author has the copyright in the book the minute they write the book. The website content, copyright, immediately once the copy is on there. So that is an asset, an IP asset of your business, whether you know it or not. All right? So it's really important to keep in mind. Federal registration is kind of a next step, and you do have to have the registration to file a lawsuit, and it can get you additional damages if you do that, but it's not too expensive, and it's not uncommon for companies, especially nonprofits, to wait until there is an infringement, then go register it, and then go file a lawsuit. So it's better to do it sooner, but you want to know that you have this right from the beginning. So what does it mean when that a copyright's created the minute the work is fixed? Is you can put this little notice, and it's tiny, but pro bono partnership is doing it right. So kind of like an SM or a TM on a trademark, you should put this C in a circle, the year the work is created, and who owns it, and then sometimes you can add all rights reserved if you want. That's what you can do for free, right? So you can put this on your photographs. You could put this at the bottom of your website, anything that's copyright protectable. This acknowledges that I know the copyright already exists, and I'm just putting people on notice of that fact. So, and then kind of talking about some of our perception benefits. This is just another thing that makes you look put together, right? It's 100% free. Stick it on there. Looks like you've got your stuff, buttoned up. That's very positive. So how do you avoid landmines with copyrights on a budget? Some of this stuff seems like common sense, and it happens all the time. So once again, when it comes to content, nonprofits will sometimes, all companies. I'm not just picking on nonprofits, but that's the that's the kind of the audience for this. All companies, it's way easier to Google search something, find a really great meme, or an image or a stock photo that fits your purpose and just slap it on your website, or include it in your marketing materials. Um, this is the kind of the other side of the coin, with copyright, is that somebody else that took that picture, even if they didn't register it, they've that copyright still exists in that. And I will tell you, there are very good crawlers, software crawlers nowadays that can find photos. And I've had clients who are like, I have no idea how this photographer found me, but they found our website and they found this photo of the Roebling Bridge that this person took, and they're like, listen, you can give me $1,500 or I'll sue you. And they just send out. They have law firms that send out these letters for people who are using these images. So be careful. Common sense. Don't use people's written copy. Be careful with clip art and those kind of things. Um, this last part is something I really want you to pay attention to too. So we now know that the copyright is created the minute the work is created, and the presumption is that the author owns it. A lot of nonprofits are scrappy, right? Uh, Maybe your friend from college is taking some photographs for you. You're relying on a couple organizations to do free stuff for you. On the side, you've got a videographer that's doing free stuff. The presumption is that those people doing that content own it. And even if you pay for it, there's people have heard of work made for hire. It's not as expansive as the words suggest. I almost wish it was called something else. Just because you pay for something doesn't mean you own it. And especially if you're getting stuff for free, you don't even have that argument. Now you may say, we don't care if we don't own those assets or those photographs. And there's some cases where maybe that's not particularly relevant, but you're building goodwill in this brand, and you want everything to flow into your organization so that you can use that stuff again. People don't use the same images in ways that could hurt your brand. You want to have control over your content. So if you have 1099 contractors, if people are helping you out, that's great. You want to have at least a basic sort of intellectual property transfer agreement. And it's not rocket science, but make sure, one, you recognize that exists, and then two, get that into your organization so that you have it and you control it. Oh yeah, what's that? Oh yeah, yeah. And so the pro bono group here says they can absolutely help with that, which is excellent. Yeah. So if that's something that you think is happening and you want to kind of clean house a little bit and do some of that housekeeping, please get in touch with this group. The last kind of major topic, and this is pretty quick, is you can see my free thing again. What's it? Do I have rights? Do I have rights to it? So that's a good question. So my clip art. So this comes up all the time. So clip art and things. So I did exactly what I suggest you to be careful of, but there's a fair use exception when it's for educational purposes. So if I was using a lot of this stuff on my my business stuff, and I'm not doing educational talks, if these symbols and these things I'm using are on my personal business website, I'm trying to raise money, I'd want to be much more careful about it. I still am careful to take things from good sources, but you should assume, don't try to rationalize this stuff. I think you want to assume as your organization that you want to make sure everything's clear that you're using with your content, and then if you're creating stuff that your organization owns it. So, all right. So trade secrets. This is the last, I think, important bucket, and these are great because they're 100% free. And I'll tell you why I say sort of in a minute. Um, but they can also last forever. So as can trademarks. So so your trademark, you have to renew it, and it can theoretically last forever. A trade secret, as long as you can keep it a secret, it's yours. So it has that potential. And so what can be a trade secret? Most people think of like the Coca-Cola formula, and you as an organization might think, I don't have chemical processes and thing. When I think of trade secrets, I think of, you know, formulations and, it. You still almost certainly have stuff, and so it just has to meet these three requirements. It's not commonly known. It has business value, and you call it a trade secret, and it can really be that simple. And so what can it include? All this stuff. So the way that I describe this to a lot of companies, and it applies to nonprofits, is what information have you learned in running your organization that if somebody left your group, they could compete with you so much faster because they knew that information. If as a nonprofit, let's say you found your 6 mega donors, how much effort has it taken for you to find and court those people? If somebody left your group, to start their own nonprofit, and they knew to call those 6 people, um, that could materially hurt your organization. So all this information that benefits your group, and a lot of it can apply to nonprofits, maybe more than you might not necessarily initially think. If it has business value, if somebody taking it could really, hurt your organization, um, keep it as a trade secret. Yeah, yeah. So somebody wanted to go back to this slide real quick. So, oh yeah, and we'll email everybody the entire PDF of the presentation, and it's being recorded too. So if you want to listen to me over and over, so keep all these options in mind, and then if you do identify, and maybe it's your giving list and how much people are giving, that could be hugely valuable. So what do you do to protect that? Okay, we have 5 minutes left. Perfect. What do you do to protect that? Don't put it on the public server. Don't put it all up on your website. Limit the people that have access to that information is the best thing that you can do, and then label that stuff secret and confidential. Call it, what it is. Treat it like that, and then if somebody walks off with it, then you might have a cause of action for that. So lastly, we've got patents here. I just want to kind of close out the buckets. You can protect, functional inventions. This is kind of the better mousetrap concept, which probably doesn't apply to most nonprofits. You can get in touch with me. I'm happy to answer questions if that does happen to be you. Probably the two most kind of basic tips here would be that you can protect inventive designs, and that applies to user interfaces now. So the Google search bar, they've got kind of the way it looks with those eyes, feeling lucky in the search with the pen. They have a design patent on that user interface. So if you have a really unique interface, design patents are cheaper than utility patents, but they're not free. If that's a value, then maybe dig a little bit deeper. But that's honestly probably about the only relevant patent-related concept. So I'm going to plug my book. I've got a book coming out, hopefully in about 3 months, called The Patent Game. And it helps non-lawyers learn about the whole patent process. And it tries to do it in kind of a fun, engaging way. I'm also a game nerd, so there's a lot of board game analogies and comparisons that kind of walk you through the whole process. So if you go to patentgame.com, even the website's still just we're still building it up. But if you want to get an email when the book comes out, that's the website. It's been about 2 years in the works, so I'm pretty excited about it. So And that's how you can get a hold of me. Uh, and thanks, everybody. Do we have questions time? We got a couple minutes. All right. If anybody has questions, I'm happy to answer them now or later. Yeah. Yeah, so there's Creative Commons licenses. There's open source for software, and when it comes to that type of content, you really just want to be aware of what the license says. There's a lot of very permissive licenses that let you use content. A lot of them require attribution. So if you use something, a lot of those licenses will say you can use whatever you like, but you have to give credit back to the original source. So there's so many of them that are out there that if you are going to take advantage of some of that content, just pay attention to the license and the restrictions so that um, you're following along with the guidelines that they have. And a lot of times, like most of this stuff, it's really easy to do on the front end, and it's a lot harder to clean up if it kind of goes sideways. Good. All right. Thanks, everybody.
Thank you, everyone, for joining us.